for May. As you heard, we're recording this session. My name is Mark Hughes. I co-chair the Ethics Committee, and the Ethics for Lunch sessions are co-sponsored both by the Hospital Ethics Committee and the Berman Institute of Bioethics. If you are interested in CME credits, that number is there at the top, the 443-541-5052. If you put in the code 38118, that will register you, and thank you for your participation today. We're going to also have that in the chat if you need that later in the presentation. Today we're going to be talking about challenges in surrogate decision-making, have a few cases to walk through, and we have great panelists to discuss this topic. So let me have them introduce themselves. Lourdes, could you start?
Sure. Thank you, Dr. Hughes. My name is Lourdes Carhuapoma. I'm a member of the Ethics Committee. I'm also a nurse practitioner in the neurocritical care unit here at Johns Hopkins, and I'm a PhD candidate at the University of Virginia. Thank you for this opportunity.
Jeff?
Thank you, Mark. Happy afternoon, everybody. We're looking forward to a great conversation. Jeff Natterman, Chief Risk Officer for Johns Hopkins Hospital, Senior Counsel for the health system, and I'm also a member of the Johns Hopkins Hospital Ethics Committee, and I appreciate having this conversation today.
Mollie?
Hi, everyone. My name is Mollie Selmanoff. I'm a licensed social worker and certified case manager. I spend most of my time in the med-surg units discharging patients, and I'm also happy to be on the Johns Hopkins Hospital Ethics Committee.
Great, thank you all. So we'll hear from each of them as we go along here. So we're going to talk about surrogate decision-making and our objectives. So in Maryland, we have the Healthcare Decisions Act, which talks about advanced directives as well as how we find authorized decision makers for patients that aren't able to make their own decisions. We're going to figure out how we find surrogates, who is going to be the authorized decision maker. And then once we're working with a surrogate decision maker, there may be difficult clinical situations, and how we inform them about the diagnosis, the prognosis, and ultimately how they make decisions on behalf of the patient. So we're going to try to cover those objectives today. I'm going to start with a case. So a 45-year-old patient is air transported from a neighboring state for management of sepsis. He tells the ICU staff that he has completed a power of attorney in case he is unable to make decisions for himself. So Jeff, how would you recommend if the ICU team were to call you, or they were calling the ethics committee, of what should they be thinking about in taking care of this patient?
Thanks, Mark. So right out of the gate, we would want to see whatever the documentation was that was mentioned by the patient. So if the patient had said that the patient had completed a power of attorney or an advanced directive, or there was some other documentation that indicated an appointment of a healthcare agent or the wishes, we would want to see that. And in seeing that, what we would look for is the language within the document that makes the appointment, when it's effective, because sometimes they're effective immediately, but sometimes most of the time they're effective upon a determination of incapacity. We would like to also see if there are numerous healthcare agents, and sometimes there could be one healthcare agent or power of attorney. There could be identified co-healthcare agents. There could be a hierarchy of healthcare agents. So there's a lot that goes into the development of these legal documents. And the other thing we would want to check for too is legal validity. So for instance, each jurisdiction, whether it's Maryland or if it's any other state, or whether it's Pennsylvania, Virginia, California, it doesn't matter. Every jurisdiction has its own laws relating to how to create a healthcare advanced directive and what the requirements would be procedurally to do that. And so we would want to be able to see that document first before we would advise potentially what any next steps would be.
So if he didn't come with it, he doesn't have the actual paper document, and he's just saying, I've got a power of attorney, we're going to ask him, can you get a family member to send it to us or something?
Well, correct. So either would be well, if the patient is a septic potentially and an extremis, that's going to be potentially difficult. But we would ask, or if there's a contact person that would be identified, an emergency contact or next of kin, following the hierarchy, which I know we'll get into in a little bit. What we would really try to do is reach out to somebody that would have that document available. It could also already be in the record if he's been a patient at Johns Hopkins before. So we would look under an EPIC under the media tab, for instance, to see if there's a prior advanced directive that was identified. But we would definitely want to reach out and see if we can't locate that document. And in the meantime, we would follow the Healthcare Decisions Act hierarchy. And whoever the next person in line would be as surrogate before we could identify the healthcare agent.
And so 2 questions with the fact that he's from a neighboring state. So when you said we'd have to check the legal validity of it, that's as it would be valid in that state that he resides, not according to what Maryland requires for it to be valid.
That's a great question. I think we have a slide that actually quotes the reciprocity statute later. But here it's either the state where the person comes from, that jurisdiction and the law. So the advanced directive would have to be legally valid in that state, or Maryland. And in Maryland, for instance, the healthcare agent has to be appointed in a document where there are 2 witnesses, neither one of whom is the agent. And to be honest, we've vetted hundreds, maybe even thousands of documents over the years. And I vetted one recently, for instance, where somebody had completed a Maryland healthcare form that they pulled off the website. And it turns out that the only witness was the healthcare agent. And that would not be a legally valid healthcare agency in the state of Maryland. Therefore, that person could not be the healthcare agent.
Okay, well, maybe we'll save that for later of like, what would you do then? But some of this, the patient still has capacity, at least as this is, we're portraying it, he's being air transported. So some of it's going to hinge on sort of doing informed consent. So maybe you could walk through the things that we need to think about with informed consent.
Absolutely. So, of course, informed consent's about the dialogue and the conversation that you have with the person who would be getting the consent and giving the consent. And then, of course, documenting appropriately on the approved consent form those elements of what a proper consent would be. And so the first and foremost issue here is to identify the proper person. And I know we'll get into that in a little bit too. But generally speaking, for proper informed consent in Maryland, you need to have those various elements, including the risks associated with the procedure type, the benefits of the procedure, and also not just the alternatives, but the risks of the alternatives. So that's another component that should be included in proper informed consent. And people have a right to refuse a procedure, right? So they don't have to consent. So it really shouldn't be coercive. If we should be doing this in a way that gives them an opportunity to contemplate these items as they're doing it. And the other thing I'll throw out there, in Maryland at least, one trial court at least has found a couple of years ago in one of the cases that we were working on, that not only is this an issue of a cause of action potentially of negligent consent, but also breach of contract. And what the court meant by that was that form that you sign is just like buying a car or buying a house, and that all those terms that you have on that form, they have to agree between the provider that's getting the consent and the patient that's giving the consent. And there has to be a meeting of the minds. So there's essentially offer, acceptance, consideration, et cetera. And so in theory, at least a plaintiff could file a breach of contract cause of action for an improper informed consent, notwithstanding the ethical considerations or notwithstanding some of the communication pieces of this or some of these elements. You've got to get the form itself right with the right signatures and whatnot. in order to avoid a claim, for instance, of breach of contract and negligent consent.
Yeah, so maybe you could tell us a little bit more about what would be negligent in terms of getting informed consent.
Sure, no, I appreciate that too. Typically speaking, based on case law, because informed consent is predominantly a matter of case law and common law. So here we're talking about inappropriate communications that would have prevented a patient from understanding all of the risks associated with a given procedure such that they can make an informed decision about whether they want to proceed with a given procedure. And so if you leave out various elements of the risks, including potentially that the patient could have bled to death, or they could have suffered serious collateral organ damage, because it's commonly known that in this particular procedure, this is a known risk. So if you leave out, for the most part, known risks, then that's going to be a real problem. The other piece to this too is that there has to be a relationship between the provider and the patient. So if you really have never seen a patient before and you don't know anything about the patient and you're about to do a procedure, you've established a therapeutic relationship. Now you've got a duty before you get that informed consent to disclose all of that risk information. So there's also the standard of care piece, of course, right? So when you're doing a procedure with somebody, as I'm sure everybody on this call knows, there are known risks of that procedure. And if you don't articulate all of that as you're doing the procedure and then following the standard of care for the procedure, then that could be a problem for not getting proper informed consent about what exactly it is you're going to be doing once you go to a procedural area. So a patient has a right to know what's going to happen to their body when they go into that procedure room, what's going to happen. And there are things that happen as a result of going in there that maybe weren't initially anticipated, but on the consent form, often you'll see phraseology that says, and damage to other adjacent organs or something to that effect, because you just don't know if it's going to happen, but you want to make sure the patient knows that's a possibility. And the real other element here, I think, is, and this has to do with the meeting of the minds and the patient absolutely understanding what the potential risks are. If we failed to disclose a given set of risks and the patient had known them and they would not have proceeded, then that could also be an indication that we breached the duty to do proper informed consent. And so just as an FYI for folks, the seminal case in Maryland in 1977 was Sard versus Hardy, which outlined these various consent elements and what would lead to a negligent consent success, case.
And so then if we think about our patient that had sepsis and maybe he loses the ability to make his own decisions. So what's needed for determining whether a patient is incapacitated, can't make their own decisions?
Another great question. Unfortunately, there's no expressed prescriptive explanation of what exactly it means to determine incapacity, other than that there are some opinions and some case law which describe the fact that does the patient understand the consequences of their decisions. So there's a little bit of description from the sources of law that we have that guide providers on how to come to that determination. The state really defers to the judgment of providers to make a determination based upon assessments as to whether or not they think the patient will understand the consequences of those decisions. And here, what you see on this slide is what it means to certify in Maryland that the patient does not have the ability to make those decisions on their own. And I'm not going to read the whole thing, but essentially what's required is you need two providers under most circumstances. There are some circumstances in the ICU, for instance, when a patient can't communicate by any means, when you can only have just the attendant, you don't need a second physician or nurse practitioner. but you have to have two providers assess the patient and then make a determination that they're not capable of making an informed decision because they don't clearly understand the consequences of their decisions, or they are just frankly incapable of communicating by any means, like being intubated, sedated, in shock and unconscious, and those types of things. One of the physicians or providers has to have examined the patient within 2 hours before making the certification. A point of confusion sometimes with this statute is that some interpretations have been that the providers have to do their assessments within 2 hours of each other, and that's not correct. It's that one of the providers has to be able to assess the patient freshly within 2 hours of making their certification.
And so if the patient lacks decision-making capacity, then we need to find an authorized decision maker, and then the law will indicate who we should seek out as a surrogate. So maybe you could just run through the list of our, options for surrogate decision makers.
Sure, absolutely. This is the Maryland pecking order, for lack of a better term, and you start at the top when you're trying to have a consenter for somebody that's been certified as incapacitated. So the very top of the list is a healthcare agent, and I want to be clear about the fact that in Maryland, there is a delineation between healthcare agent and then everybody else underneath healthcare agent that is called a surrogate. So the healthcare agent is the healthcare agent. They're not referred to as the surrogate. Legal guardian and down in this list would be referred to as the surrogates. And that becomes legally important in some circumstances when it comes to what a healthcare agent can consent to and what everybody else can consent to under Maryland law. So you start with healthcare agent. I imagine if I were to ask a show of hands in a room of everybody on the call right now, how many people have an advance directive? My guess is we would be surprised that a lot of people probably don't. Often when I ask this question in a public forum, I get about maybe 20, 30, tops 50% of the people have an advance directive. So I highly recommend you fill out an advance directive, and I'll get to that in a second. But legal guardian would be next. So most people that come in as an encounter to the hospital don't have a legal guardian. Some do. We would want to check the guardianship paperwork too, by the way, just like we check advance directive paperwork, just to make sure what the duties, responsibilities, and limitations are of the guardianship. And in fact, what I would throw out there is some people will say, I have a power of attorney, and it turns out that they have a financial power of attorney, but there's not one piece of language in there that says anything about healthcare. That's a problem. So that the power of attorney that would appoint a healthcare agent has to specifically say they are appointing it for medical purposes, not just for financial. We go down the list, spouse or domestic partner. Domestic partner was added in 2008. As I've always told people, you can't have both at the same time. And this becomes really important because we have had cases where there has been an estranged spouse where they haven't filed for divorce or they haven't executed a separation agreement. And in theory, that spouse is still the consenter unless you appoint your significant other as a healthcare agent, which then would trump the spouse, if that makes sense. So spouse or domestic partner, and there are identified proofs of domestic partnership. So if you have somebody that's saying they have a domestic partner, we generally presume that that's true, just like we don't ask for a marriage license, right? When somebody says I'm the wife for the husband. But if it becomes a question, then we start asking for different proofs of domestic partnership. And they could be like lease agreements and any kind of bills that they're sharing. And the Attorney General actually has a list of different things on their website that will show you what the proofs are there. Then adult child, then parents, adult siblings, and then of course, anybody else that would be a family member not identified higher up. It could be a neighbor, it could be a friend, and somebody that can attest to the fact that they know who you are and are willing to sign an affidavit to that effect.
And just again, because this patient was coming from a neighboring state, so I know like for Pennsylvania, like the second spouse is lower on the list than the adult children, we would follow the Maryland hierarchy of surrogates rather than whatever state the person's coming from.
That's correct. So Pennsylvania actually has a common law statute. We don't in Maryland. We follow this statute and this list right here.
All right, and so you encourage people to do advanced directives. And there was a comment in the Q&A that with Maryland, and there's CRISP, so the Chesapeake Regional Interface, I forget what it all stands for, but a network of the neighboring states where there might be an advanced directive posted in that. Can you say anything more about how we track down advanced directives?
Well, I mean, certainly if you actually have the document that's available, and it could be through CRISP, it could be through a paper record, it could be through our record, anywhere we can get hold of that most recent document, it's got to be the complete document. Oftentimes in these situations, you'll have a portion of it, but in order to determine legal validity, we need to see the signature line in addition to the rest of the body of the document itself. So it really depends on the completeness of what you find and where you find it.
You had mentioned before about reciprocity. You want to say anything more about that?
No, we often will get documents from other states, and the first thing that we would do here is see if it is valid under Maryland law with 2 witness signatures. You don't need a notary in Maryland, so really you need 2 separate witnesses, neither of whom are the agent. And generally speaking, we're looking for the patient's signature, of course, and we'll vet it first through Maryland law. And if it comports with Maryland law, it just saves us having to go to Ohio or Nevada and check out what their laws are in the opposite state. But we've done that before too, where we've verified out-of-state statutes to look at what their up-to-date requirements are if it's not in aligning with Maryland law. So we will accept an out-of-state advanced directive as long as it comports with either one.
So let's say this patient wasn't able to supply the advanced directive. We can't track it down. Can you say anything about oral advanced directives?
Oh yeah, sure, thanks. And I apologize. I feel like I'm taking up a lot of the time here. So
I'm going to you as the expert.
No, that's good. So Maryland does permit an attending physician and a witness to go to the bedside. And if a patient wants to make an expression in front of the provider and a witness, then they can do that, and they can create an advanced directive appointing a healthcare agent orally that then the provider would document in the record the nature of the conversation, what the patient said, and the witness also would have to document that they were a witness to that conversation. And then they would have an effective advanced directive identified in the record. We always recommend doing a written one that is transportable, for instance, because not everybody's going to see necessarily in a record, let's say at another hospital, an oral advanced directive that was established at Johns Hopkins. But nonetheless, for encounters here that we're treating a patient, we could rely on that as long as they had capacity. Let's be clear. You have to be careful about the capacity piece because there have been some cases where it's been equivocal, especially if they're getting narcotics or if they're in the early stages of dementia. We're not sure, they're being evaluated for delirium. But generally speaking, for a patient with capacity, you can do an oral advanced directive with a witness and making sure that you document it in the record.
And so even if the state that they're coming from doesn't have a provision for oral advanced directives, the fact that they're being treated in Maryland, we can do the oral advanced directive.
That's correct. That's correct. And so that's another reason why it's good to encourage patients to do a written advanced directive that would comport with their state, because if they go back to their state may not recognize our advanced directive in Maryland, right? It goes the other way too. So wherever they're going back to, you would want to make sure that whoever they appointed here while they were here, once they go back, they should at a minimum be informed that you may need to consult with somebody in your state or do an advanced directive in your state just to make sure it comports with your own state law in case you go to a hospital there.
Okay. So I guess the other thing is if they filled out the advanced directive, had a written one where they didn't do it correctly, like they named the healthcare agent and the healthcare agent served as a witness, we could have them do an oral advanced directive here where they might name that same person, but now it's valid because we've gotten it properly witnessed.
Correct.
Okay. So just just for those that work here at Johns Hopkins, I wanted to let you know that there are tips and tricks for Epic about designating a healthcare decision maker. So in the ACP section, there's a place where patient contacts are listed, and then you can determine if they are going to be the decision maker for the patient, whether that's a healthcare agent that's been named in an advanced directive, or it's one of these surrogates based on the hierarchy that the Healthcare Decisions Act says. And so once we have a patient that is incapacitated, we have to determine who the decision maker is going to be. So that's one step for the healthcare decision maker. And then the next step is making that active once the person loses capacity. So there's a checkbox in that section for that. And then this one says healthcare agent, but it may say surrogate or guardian to differentiate it from the healthcare agent. And then there is a note template for creating an oral advance directive. And as Jeff said, the two things that need to be there are that you put in the name of the witness. So someone else on the healthcare team is witnessing your discussion with the patient, and then they are also listed as a co-signer to that note. And as this says, they're acting in good faith to serve as the witness, and then they co-sign that, goes to their in-basket, and they co-sign, and that becomes official. And then having this paper trail, so actually printing that out, maybe, I guess, giving that as a copy to the patient, and then also sending it to medical records, our health information management services, to scan into the chart beyond just the electronic version. Does that all sound correct? Okay. So let's take another case. So this is a 56-year-old. She is found unconscious on the street. She has no identification. She needs to be emergently intubated for respiratory failure. So EMS does that out in the field. She's brought to the hospital, to the emergency room. She's diagnosed with COVID-19 pneumonia. And now she's on mechanical ventilation, needing treatment for the COVID, and additional decisions are going to need to be made. So first of all, just the fact that she was emergently intubated. Can you say anything about that, Jeff?
Yeah, absolutely. So first of all, if she's unable to communicate by any means, you really, well, let's back up for a minute. If you have a true life and limb threatening emergency and the patient is unconscious, the law allows for us to perform whatever those procedures may be. There's a whole, thanks for pulling that up, Mark. There's a whole list of requirements under the statute to do treatment without consent. So we're going to save the person's life right out of the gate. And then after the fact in the medical record, we would end up documenting those elements, meaning it was an emergency under the circumstances. There was nobody to sign consent. Sometimes there's somebody standing right next to them that could give informed consent. But if there's nobody immediately available and wasting time to try to find somebody would cause life and limb to that person, then really, if there's a substantial risk of serious harm or death to the person, then we would just go ahead and treat without consent. And I know sometimes in talks that we've given in the past, somebody said, well, can't two physicians just sign the consent form on behalf of the patient? And the answer is no, that's not a legal procedure for consenting. So if it's a true life and limb emergency, you can treat without consent, but you've got to be able to document the elements that resulted in you doing that.
Okay. So now, Mollie, we've got a patient that is unconscious. She didn't have identification, and we're going to need to take care of her in the hospital. How would you go about finding a decision maker for this patient? Let's say she remains unconscious.
Sure. So this happens a fair amount. We have John, Jane Does come into the hospital. And oftentimes when they're found, they don't have any identification with them. So the first thing we can start with is checking the scene. I call the police department often, or the medics, to see if there was anybody there who either called 911, left any information, because sometimes that's in the police report or the EMS report, but it's not actually brought to the emergency room. So that's often my first step, is calling the medics who brought in the patient, which is often hard to track down, and to see if I can locate somebody who brought in the patient. Who called in the emergency. If that isn't successful, we oftentimes have the address of where the person was brought in from the radio report. So I may reach out to Stephen Prozoralik in security, who can do reverse searches on addresses to see if anybody lives there, or if anybody lives right around there. So it's unlikely that that person just happened to be found outside of their house, but sometimes we can identify somebody from that way, or at least if we know where they were picked up. Sometimes police can go out and survey people that are hanging around that area. Now, of course, these things are often tricky, and we oftentimes aren't able to find a decision maker. If the patient has tattoos, that's another way we can reverse search tattoos. Not me, but Stephen Prozoralik is happy to help with that. And then I would say maybe the last option, the last easy option, I guess, would be, I'm sorry, I lost my train of thought. What else do I do? Seeing if the patient has any other identifying features on them. So like one time we had a patient come in with dentures, and we were able to try to use the dentures. Fingerprints. Thank you, Caitlin. That's what I was thinking of. So right now, the police aren't doing fingerprints unless it's a victim of crime. And that's been during COVID. We did have one case recently where I pressed them a little further, saying that this patient is actively dying and we would like to find a decision maker. So could you please come fingerprint them? So sometimes that is another really good way to try to identify the patient, but it is oftentimes hard to get the police to fingerprint a patient unless they're a victim of crime. If at that point we still have no idea who this patient is and they need something that would be more of an elective procedure, such as, let's say that they continue to be intubated and they are going to need a trach. That would be a procedure that needs consent. And so if we truly cannot find anybody, we may have to go down the road of guardianship, where we have two physicians certify that the patient is incapacitated and in need of a guardian, and then we go to court for that. It's often a lengthy process, and it does cause the patient to sometimes be in the hospital longer than they medically need to be, just due to the process. But that is what happens if all attempts are made to locate a next of kin or a decision maker and we're unable to find one.
Let me just back up and ask a couple of questions. So when you're using the address, is it the police that would survey, neighbors? Can you as a social worker reach out to people, or is that a HIPAA violation?
So if I get the information as to who called in the incident, I will call that person. But I myself would not call neighbors in the area. Sometimes the police will do it, and sometimes Stephen will also assist with that. Or I would say if I do call other people, I try to be as vague as possible and just explain we have somebody in the hospital that we think might be related to you, or you may know, and could you give us any information? And then they'll either say yes or no. If they have no idea what I'm talking about, then I know that they weren't there.
Okay, so even in cases where you have identified a person, but now you're looking for a decision maker, there'll be steps to try to track that person down.
Yeah,
Not
absolutely.
just, okay.
Yeah.
All right, any other comments or questions about what we do when the patient is incapacitated, unconscious, and we need to find a decision maker? What about things like towards the end of the hospital? You're talking about they might need a tracheostomy or other interventions while they're in the hospital. What if they're approaching discharge, like they're going to go to a rehabilitation unit or to a nursing home? Can you say anything about the surrogate decision maker, how we find that next of kin in those circumstances?
Yeah, so if we have somebody who needs to, let's say a little slightly different from this case, but that a patient needs to go to a nursing facility and we know who they are, but they don't have any, or they haven't signed any paperwork. So they're incapacitated. They don't have an advance directive stating a healthcare agent. And so there could be multiple family members that are saying, I'm next of kin. No, I'm next of kin. No, I'm next of kin. And so we, of course, have to go through the pecking order that Jeff described. But if there is no documentation and the patient is unable to sign an advance directive, that's another time where we may need to go to court for guardianship, because oftentimes nursing facilities don't want to accept a patient without knowing who medically is going to make decisions for them, and then also financially who's going to make decisions for them. And I will say almost nobody that I've seen in the hospital has a financial POA document completed. So we often hit that a hiccup there. Sometimes nursing facilities will accept patients and work out the finances later. But I have run into situations where we still need guardianship because the patient is not going to regain capacity, which could be the issue in this case, and they're going to need rehab, and so they need somebody to sign the paperwork to get them there.
Great, thank you.
Mm-hmm.
We'll go on to case 3. So here we have a patient, 70-year-old, chronic anticoagulation, admitted to the neurocritical care unit, has a hemorrhagic stroke requiring surgical evacuation of all the blood. Post-operatively, he remains unconscious on mechanical ventilation. He does have an advance directive naming his wife as his healthcare agent, and a living will that indicates he would not want life support if he were in a permanent coma or persistent vegetative state. So now it's going to be a matter of interpreting the advance directive and having his wife as the authorized decision maker. So Lourdes, what are your thoughts about this case?
Sure, thank you, Mark. Well, I think there's a few key points that we all need to consider, and I appreciate you including this in the slides, because there are certainly times that clinical situations that we face where advance directives are not always necessarily applicable. So in this particular case, we have a patient that has suddenly lost the ability to make decisions for themselves. So we have identified, and as Jeff pointed out, a healthcare agent, not necessarily a surrogate decision maker here in this case, is tasked with the role of making these critical treatment decisions on the behalf of the patient. And in this situation, because the prognosis is uncertain, the living will is really difficult to interpret and apply. So I think we need to talk about some key steps into how we address these clinical situations. We can go to the next slide. So a few things that we need to consider is that, as I mentioned, advance directives are sometimes difficult to interpret and apply, especially in clinical scenarios where prognosis is uncertain. And surrogate decision makers or healthcare agents may lack sufficient information about patient preferences and values, specifically in sudden onset illness states where patients have a precipitous decline in health. And it's really unclear as to whether or not patient wishes prior to the decline may be applicable in a new health state. And I'm going to be talking about this in particular in the next couple of slides, because it really, it needs to be mentioned into how we address complexities in decision-making. So here in this figure, it demonstrates the trajectories of illness for patients without limitation of life-supporting therapies, but I wanted to highlight the trajectory of illness in cases in which advanced directives are difficult to interpret and apply for surrogates tasked with making these critical treatment decisions on the behalf of patients. So you'll see here that in the upper right-hand corner of the figure, a neurocritical illness state is illustrated, and the trajectory of illness in this clinical scenario is often sudden, with a precipitous decline from a normal baseline. And the trajectory is applicable not only in neurocritical illness states, but also in other clinical scenarios, such as trauma, as an example. These situations really tend to leave surrogates with very little time to prepare for consequential decisions. Specifically in neurocritical care units, approximately 70% of patients present with an acute loss of cognitive and physical function without any prior symptoms at baseline. And patients with acute neurological injuries often do not progress to death, as you can see in this illustration here, but instead they display a slow and prolonged recovery state or fail to demonstrate any improvement at all, leading to severe and permanent disability. And in some very severe situations, it can lead to a persistent vegetative state. And so this is really consequential because it leaves advanced directives very difficult to apply and inapplicable in these situations. And death in many cases is the result of a decision to withdraw life-sustaining treatment. And these decisions are typically made by surrogate decision makers or healthcare agents. We can go to the next slide. Okay, so as I previously mentioned, that in some situations, it's really unclear as to whether or not patient wishes prior to decline may be applicable in a future disease or disability state. And to answer this, surrogates are very interested in knowing what the patient's quality of life will look like in the future. And there really is no easy answer in these clinical scenarios. And this gray area or unknown is what makes decision-making so incredibly difficult in these situations, even when an advanced directive is present and available for us. So using stroke as an example, we can look at model A here. Using stroke as an example, Creutzfeldt and colleagues, they described three hypotheses of quality of life. One hypothesis of quality of life really describes it as the gap between our expectations and experience, depending on what period in our lives an illness may occur and on what resources we may have available to cope with this. And there are three potential trajectories of quality of life following stroke. Each of the models begins with a baseline quality of life gap where expectations and experience run parallel to each other. And when the stroke occurs, experience falls below expectations, and this gap tends to widen, which adversely affects quality of life. If the symptoms resolve, the gap may narrow again, and we can look at model B. Okay, so if the gap may narrow again, implying a return to the patient's previous quality of life, which is noted in model A. But in model B, if there's no recovery or the expectations do not change, the gap either persists or widens. And in this case, the quality of life is worse than even before. And then in model C, after some time, the patient learns to accept the disability and recalibrates expectations, and the gap begins to narrow. And in this situation, the quality of life may eventually be no different in the patient who recovers from their stroke, as in model A, and the patient who is left with a permanent disability state, as in model B. But the arrow here in C suggests a change in experience, where experience may even exceed expectations, resulting in what has been coined as the disability paradox. And most current measures of quality of life refer only to the time period before this adaptation, when the illness has a predicted negative impact on a patient's quality of life. But it's typically as this gap widens between experience and expectations and prior to the potential for adaptation that we task healthcare agents and surrogate decision makers with making really critical treatment decisions. And in many cases, they're decisions that involve goals of care. So to maintain, limit, to forego life-sustaining treatment. And to make these consequential decisions, we typically ask surrogates or healthcare agents to reflect on who the patient was before their illness. We ask what they enjoyed to do, what they disliked. And this is a very empathetic approach to take, but I think it's important to understand that it can have some unintended consequences because surrogates and healthcare agents typically tend to remember their loved one as someone who was healthier, more active, and less dependent than their current state. So translating patient preferences into treatment choices and treatment decisions is really based on predicting future quality of life. And there's really no true clear answers on how to advise surrogates in these really difficult situations. We can move on to the next slide. And so, taking this all into account, the psychological impact of decision-making on surrogates is overwhelming. And many surrogates often express doubt, guilt, and regret surrounding their decision. It's been cited in the literature in numerous different papers that family members, and in one paper in particular, nearly 82% of family members who participated in the end-of-life decision-making process experienced post-traumatic stress with moderate to severe risk for post-traumatic stress disorder. And about 34% of surrogates met criteria for at least one psychiatric illness within a year of a patient's death. So as we can see, decision-making really takes a toll on healthcare agents and surrogates. Approximately 1/3 of surrogates of stroke patients experience complicated grief or stress reactions. So these decision-making process is very burdensome and overwhelming to surrogates and healthcare agents. And we really need to understand how to be able to assist and guide through this process. The next slide. Thank you. So how do we currently support decision-making and how should we be supporting decision-making? These are very hot topics right now in the literature. So one of the one paper that I found in particular cited that there's a lot of inconsistencies in how we deliver, especially prognostic information to families, and how we account for that in looking at patients' advanced directives. So providing a common message is critical to informing surrogates and healthcare agents and guiding them through the decision-making process. And one approach is to perform huddles where we involve input from all clinicians prior to going into family conferences, just to avoid inconsistencies in messages. And also discussing not only the chances for survival, but also the potential for disability, as well as what function may be preserved. And exploring the patient's values and preferences within this context of not only survival, but also disability and what may be preserved is really critical to guiding families through the decision-making process. And, one of the obvious things, but we don't always consider it obvious when we're asking families to make these critical decisions, is to offer adequate time to consider goals of care decisions as well.
Before moving on, maybe I can just ask a question from the chat, because you mentioned, patients' prior wishes or maybe their previous life experience and how they lived their life. And now we've got, a change in circumstances. So the question from the chat was, with regard to the advanced directive, if the family's needing to interpret that, for instance, is there a time limit on the validity of an advanced directive or living will? Are there any cases in which the treatment options have changed since these were made and may have impacted how they may have written their advanced directive or living will? So maybe not just naming the healthcare agent, but maybe this patient in particular talked about persistent vegetative state and coma and so on. But now time has elapsed and now they're in a different situation. Do you want to comment about how you work with the families to help them reconcile the advanced directive, what the patient might to think about their expected quality of life, the anticipated quality of life, et cetera?
Sure. So, it takes some time to be able to prognosticate in terms of, persistent vegetative states. So, we're looking at decision making even much earlier on in the clinical course where these critical decisions need to be had. So, in looking at this question, is it, I'm asking, Mia, is this more of a legal question in terms of the validity of the advance directive? I'm wondering if I can get some clarification.
While we're waiting for that, maybe Jeff, once an advance directive is signed, it's valid indefinitely? It doesn't have to be like renewed or...
No, there's no time limit. There's no expiration date unless the person puts in there. It's a creature of how it's written. So you have to read it thoroughly to see what the intention was behind what was written. I have never seen an advance directive that had an expiration date. Not that they couldn't, but that's why it's really important for people to review them from time to time, because I've got one from 10 years ago. I should look at mine, even though it hasn't changed much, just to make sure that you're updating it if you need to. And the other thing I'll throw out there, since you asked the question, is when you do an advance directive, you should be giving a copy to your PCP, right? And your agent. So if you have an update to that advance directive, then you need to make sure that those people have the new copy of that advance directive, because as soon as you create a new one, you revoke the old one by date. So the date of the new advance directive becomes your new advance directive. And by the way, statutorily, you can revoke an old advance directive if you want to exclude prior agents because circumstances have changed from a relationship point of view as well. Just an FYI.
I just wanted to also circle back with Mollie and or Jeff. There were questions about, so what if you have to wait for the guardian? If no guardian is found, do the physicians make decisions for the patient during the hospital stay? And would the patient remain in the hospital indefinitely until there's a court-appointed guardian put in place?
So short answer is yes, they have to remain if there's if they don't regain capacity and we need somebody to make a decision as to where they're going to go. They would continue to receive routine care, but the medical team could not consent on their behalf to an elective procedure. So I'm thinking of a case previously where a patient came in with cardiac arrest and had an endotracheal tube. We had to wait for a guardian to be appointed to get a tracheal tube and a PEG tube for nutrition because they were considered elective procedures. So yes, there were risks because the endotracheal tube was left in longer than it probably should have been. But legally, the doctors couldn't make the decision as to whether or not to do that procedure. Do I have that correct, Jeff? At least that's what happened in the case I had.
That's correct.
And other aspects of ICU care. So if the person developed a ventilator-associated pneumonia, the physicians could institute treatment without a consent.
That's correct too. I mean, look, if it's a situation where there's something emergent that happens that's life-threatening, that's one thing. But if you've got time to be able to get a court order and a guardian, then that's the procedure that we should do. I mean, if it's an ET tube that's eroding through and it's going to cause a pneumomediastinum and they're going to bleed out because it goes into their carotid and those kinds of things, then you're going to do what you need to do to save that person's life. And then we'll go to court or continue that process to try to get a guardian.
There's another question, and maybe for all of you, Lourdes in particular, of what guidance are we giving people regarding creating their advance directive, like sort of anticipating these future hypothetical health states? Are there any requirements to help people understand their options fully, or should there be?
Yeah, I think that leads nicely into the next discussion point. Is, how should we be guiding, families? Not, I think this is being preemptive, right? And how you guide people into creating their advanced directives, but also how do we guide families, if an advanced directive is not present or if it's not really applicable? And how do we really look at what people would want, especially in disability states. And I think that this is a really complex answer. And looking at this disability paradox and really researching has really, opened my eyes in particular to the fact that, people tend to think that they may not want to live in a disabled state, but once in a disabled state, they said that they wouldn't want it any other way. And particularly in talking with survivors of neurocritical illness states, this tends to be a trend. So how do we guide individuals in creating advanced directives that give at least the freedom or the verbiage to allow healthcare agents and surrogates to make the best informed decision that they possibly can, knowing that individual? I think it's difficult to do. I'm not sure that there's a straightforward, easy answer that I can provide. I'm not sure if Mollie or Jeff, if you have any input here.
So I would say that in being the social worker on a med surg floor, and then also through the ethics committee, what I've often encouraged family members to do is to think about, based on previous discussions with their loved one, whether it's family or friend, what was important to them in their life? What have they said is meaningful? So I remember one case in particular, a patient told her daughter, I think, I absolutely under no circumstance ever want to go to a nursing home. And so the daughter had to use that sort of information to decide, well, if they do get whatever procedure it is, likelihood is they're going to need to go to some rehab at a nursing home. So just take that into consideration, knowing that your mother has made it extremely clear that that's not what she wants. But then going back to what Lourdes says, it's possible that that person may actually want that in the end. So that's often what I start by encouraging people to do, or just to see if there's any conversations they've ever had about what is meaningful to their life. And then also just paying attention to what has been meaningful to their life. So if being around family and friends is what's most important, and the thought of not being able to communicate with somebody is detrimental to their quality of life, to consider those sorts of things. We had a patient yesterday whose family said he would never want to live if he couldn't drive and be independent. And so they were able to make his decisions knowing that it was his life to him was not worth living if he weren't able to do those things. And that was just by knowing the person and having a good relationship and really thinking about what's important to them.
And some advanced directives now include, sections where you could put in free text about those kind of things, preferences and health states that would be acceptable or not acceptable. Jeff, I know you may have to leave soon. Any final comments from you? Then we'll come back to some of these other questions that Lourdes presented.
No, only that I am struck and mindful by sometimes surrogates or healthcare agents don't always decide based upon their experience of what they know of the patient. That sometimes there's a huge, and I'm not a psychiatrist, that I fully admit that, but boy, there's an awful lot of psychology that goes behind somebody that doesn't want to do something because they don't want to feel guilty about having, because that's what the patient wanted. So there's this, there's a real nuanced element of people that have to make very tough decisions for loved ones at a certain part of their life. And I know how tricky it can be to follow an advanced directive sometimes if you disagree with it. And so that's why I really think the ethicists that are involved in these situations are a critical component of trying to get to that endpoint or to a future point where the family or the surrogate or the healthcare agent feels comfortable in making the decisions that they ethically should be making.
And also the fact that some patients will say, I give discretion to my surrogate, even if it might disagree with what I want, they should use their best judgment of the best interest, in whatever they're facing as the decision. Any other questions or comments from our audience? We're just about at time. Lourdes, that last question about, connecting with other surrogate decision makers, anything like that happening in the neurointensive care unit?
There's some literature around social networking for experienced surrogates, those who have gone through the decision making in the past, and connecting them with current surrogate decision makers to, although the clinical scenarios are maybe different, but guiding them into what their thought process was, what information they gathered, and how they really came about making this critical decision. It's starting to pop up in the literature, and I think it's going to be interesting to see if there's any benefit from connecting surrogates with each other.
As long as it's not violating any privacy principles.
Of course, of course. Of course.
Okay, well, we'll wrap it up there. I want to thank everyone for their participation. Thank our panelists for a great session. And we'll see you next month, hopefully. Take care all.
Thank you.